Hi, in this session today we will discuss guarantee as it's defined in the Indian Contract Act 1872. Section 172 of the Indian Contract Act defines contract of guarantee as a contract to perform the promise or discharge the liability of a third person in case of his default. The section further provides clarity on three parties who are a part of the entire contract, which is surety, principal debtor, and the creditor. The person who gives the guarantee is called the surety. The person in respect of whose default the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. Let's look at the essential elements of a guarantee. The guarantee can be in oral or in writing. Guarantee may be in oral or in writing, and according to English law, only a written and a signed contract of guarantee is valid, whereas in India, both a written and oral hold good in court of law, provided we are able to substantiate and provide an evidence that yes, there was an oral guarantee which was given by the surety. Difficult to prove, but at the same time, as far as the court of law is concerned, both written and oral have the same value. The second is the guarantee not to be obtained by misrepresentation, which means when the guarantee is being given by the surety, he should have clear um, he should have clear visibility of what he is giving guarantee for. The guarantee the creditor should not obtain the guarantee by misrepresentation of facts. Section 142 states guarantee obtained by misrepresentation is invalid, and any guarantee which has been obtained by means of misrepresentation made by the creditor or with his knowledge and assent concerning a material part of the transaction is invalid. The third key essential element is guarantee not to be obtained by concealment of material facts. As per the section 143, any guarantee which the creditor has obtained by means of keeping silence as to material circumstances is invalid. The fourth essential element is the tri-party agreement. Any kind of a contract of guarantee is a tri-party agreement between the principal debtor, the creditor, and the surety. There are three contracts which typically get created in case of a contract of guarantee. The first one is between the creditor and the principal debtor. The second one is between the surety and the principal debtor, and the third one is between surety and the creditor. The last essential element of a guarantee is there must be a free consent of all the three parties. Any kinds of a force applied on any of these three parties will result in the contract of guarantee being invalid. Now let's look at the difference between the contract of indemnity, which we had covered in our last session, and the contract of guarantee. The various heads under which we can do a comparison of the indemnity and the guarantee. The first one is number of parties. Indemnity contract includes two parties, which is indemnifier and the indemnity holder. Whereas in case of a contract of guarantee, it includes three parties, namely creditor, surety, and the principal debtor. The second is the number of contracts. In case of indemnity, there is only one contract, which is between the indemnifier and the indemnity holder. Whereas in case of contract, there are three contracts which get created, which we had discussed earlier as well, that the contracts are between the creditor and the principal debtor, between surety and principal debtor, and surety and the creditor. Regarding nature, as indemnity contract includes two parties and one contract, it's said it is simple in nature, whereas a guarantee includes three parties and three subcontracts. It's considered to be a little complex in nature. Regarding liability, no classification and sharing of liability. happens in case of indemnity. Its absolute liability rests with the indemnifier. Whereas in case of a guarantee contract, two types of liability exist, namely primary and secondary, which will be applicable to principal, debtor, and surety respectively. Regarding recovery, any compensating indemnity holder's loss, indemnifiers can't recover that amount from any person. Whereas in case of a guarantee, if surety makes payment to the creditor, he can recover that amount from the principal debtor. Interest of the parties, indemnity contract gets formed upon indemnifier's interest, whereas in case of guarantee, a guarantee contract gets formed upon principal debtor's interests. So those are the key differences between the contract of indemnity and contract of guarantee. Moving ahead, let's look at the different types of guarantees that we have. So we have two kinds of guarantees. One is specific guarantee and the second one is continuing guarantee. In case of a specific guarantee, when a guarantee extends to a single transaction or debt, it is called a specific or simple guarantee. It comes to an end when the guaranteed debt is duly discharged or the promise is duly performed. In case of a continuing guarantee, as per the section 129, when a guarantee extends to a series of transactions, it is called as a continuing guarantee. The liability of the surety in case of a continuing guarantee extends to all the transactions contemplated under the evocation of the guarantee. There are certain scenarios or situations when the revocation of or termination of continuing guarantee can happen. Let's have a look at those specific scenarios. One, the revocation can happen if a notice is provided, which is by notice. It can be revoked by surety as to the future of transactions by notice to the creditor. It is as per section 130. Um, by the death of the surety, if the death of the surety happens so far as regards future transactions, section 130 one, the continuing guarantee it gets revocated. By variance in terms of the contract, variance made without surety's consent in terms of the contract between the principal debtor and the creditor discharges the surety as to all the transactions subsequent to that particular variance as per section 133. So any kind of variance which happens is going to result in for a reason of revocation or termination of a continuing guarantee. By innovation, a continuing guarantee can be also determined by novation, which means substitution of the new contract for the old one. Release or discharge of the principal debtor. If the principal debtor is released or discharged by any contract between the creditor and the principal debtor, or by any act or the omission of the creditor, the continuing guarantee is terminated. This is defined in section 134. Act or omission imparting surety's eventual remedy. If the creditor does any act which is inconsistent with the rights of the surety or omits to do any act which is his duty to the surety requires him to do, and the eventual remedy of the surety himself against the principal debtor is thereby impaired, the continuing guarantee is terminated or revocated. Loss of security. If the creditor loses or without his consent, the surety parts with the security given to him by the principal debtor at the time of the contract, the continuing guarantee terminates. This is defined as per in the section 141. So we have covered today the guarantee as per the Indian Contract Act. What are the essentials of the guarantee? Essential elements of a guarantee. What's the difference between contract of indemnity and contract of guarantee? We have looked at what are the two kinds of guarantee and what are the situations or scenarios in which the revocation or termination of a continuing guarantee can happen. You can download this presentation from www.juristknowledge.com. Thank you.